about 6:02. And I'll get some of this housekeeping out of the way. So welcome to our webinar. We are really happy to have all of you joining us today and learn some employment law implications of COVID-19. I'm your facilitator this evening. My name is Jill Vinskaitis, and I always wear many hats. Some of the hats I am wearing right now are starting with my home base. I'm the practice administrator for Drexel Hill Pediatric Associates. I'm the chairperson of the leadership team of the Pediatric Practice Management Alliance for the AAP. I'm one of two managers on the board of directors for the Delaware County Medical Society, and wearing the hat for which we are bringing this education to you this evening is my affiliation with PAHCOM, where I have worn many hats, but currently help the national office with certification and special projects, and on the local level, I'm the current president of the local chapter of PAHCOM, for whom is bringing you this timely topic this evening. First, let's start with some, I'll get to the next slide here. Let's start with some quick housekeeping items. Attendees are muted. If you have a question, please enter it into the questions box. We will attempt to address as many questions as we can at the end of the presentation. Next, let me do a sound check. With so many of you on the call this evening and muted, I want to make sure you can hear me. Please take a moment to raise your hand in your panel. The numbers are climbing. We have at least 86 of you, over 200 have registered this evening. Not many of you raised your hands, so I'm hoping that, okay, more of you are raising your hands now. Okay. Great. For those of you who did not raise your hand, feel free to type your audio issue in the questions field, and I can attempt to give you tips in a little while by typing back, or you can try to log off and log back on again. Let's see, next we have 95% of this presentation covers nationwide issues. George Hlavac practices law in Pennsylvania, so a few of the topics are state specific. As always, we want you to verify what is required in your own location. So let me do a quick poll to see how many of you on the call thus far are from Pennsylvania and how many of you are from outside. Again, we're just waiting for some more attendees to join, but let me do a quick poll. All right. We want to, oh good, you guys are right on the ball here. The numbers are climbing. Oh, there's a lot of you who are not in Pennsylvania. Right now, 67% are outside of Pennsylvania, 33% of you are in Pennsylvania. All right, that kind of gives us a good gauge. I'm going to close that poll and bring you back to my presentation. Okay, a nice way, so thank you very much for taking the time there, and let us move on to the presentation. A nice way to introduce George is reading a short testimonial from Marianne Tyler, who is a friend and a colleague whom I've known for years, and together we've been listening to George every chance we get. So here's her testimonial. I have been listening to and learning from George Hlavac for many years while wearing a healthcare administrator's hat. The team at HHE, Hoffman, Hlavac, and Easterly, have demonstrated their dedication to defending, supporting, and of greatest value, educating their clients. Now, a couple of years into a completely different field, without the support of organizations like the Delco chapter of PAHCOM, I deal on a weekly, if not daily, basis with a whole new set of compliance issues and HR challenges. I would not be doing my job to protect my company from lawsuits and financial distress without the support of my team at HHE. The corona pandemic has dealt all of us an entire new set of issues, compliance, and absolute fear at times personally and professionally. Regulations and our responsibilities are changing daily. The team at HHE has been that constant source of up-to-date information, clarification, and as I have requested of late, my own personal support group. Dare I say, they bring their sense of humor to their work, which has sometimes been the best medicine for my state of mind. I wish the same for all of you, my old friends at PAHCOM. Listen and learn, and be assured this team has your back. Be well, everyone. And I just included a couple photos here. We did a conference, the two photos on the left, and Delaware County Medical Society on the right. He's holding his baseball, and you can see that he's very participatory. So it's interesting to hear him over the phone versus seeing him in person, but he's just as lively, just as packed with information, and we're very excited to have him here this evening. So let me switch over to George's screen and let the presentation begin. So let me change screen. All righty.
Okay, thank you, Jill. Thank you, Jill. Welcome, everybody. This is a very different type of presentation for me. I'm used to and enjoy much more the opportunity to be in front of everybody and interact and see everybody. And it's been a learning process for all of us. This webinar industry, I guess, has become a cottage industry these days, and everybody's becoming very, very adept at handling the webinar. So I want to thank Jill for setting this up with the Delaware County PAHCOM, and I want to thank Marianne for that very nice testimonial and introduction. I guess might as well start with, the fact that we're in uncharted territory here. I've been practicing labor and employment law exclusively for the last 25 years. And what we're dealing with now is something that I never thought we would have to deal with in my wildest imagination. I'm sure many of you out there are in the same boat. You've been doing HR work, or you've been a business owner, or you've been handling practice things for your practice for a long time as it relates to HR stuff, and you've never had to deal with this. It's basically a new type of law that's developed called pandemic law, and you're learning it as we're learning it. Probably one of the biggest things that I have seen over the course of the last month is the proliferation of Google-based lawyers that exist out there in the world these days, mostly your employees. Everybody is very interested and concerned about what their rights are and what an employer's obligations are in these very difficult times. And I'm sure many of you have had this happen where you have your employees contacting you to tell you what their rights are, to tell you what the law requires of you as the employer, as the practice. Interestingly, I would say 85 to 90% of the time, they're 75 to 80% correct, but there's a big difference between being 80% correct and 100% correct. There's a lot of information out there in terms of what your obligations are these days. Not all of it is accurate. Obviously, we're dealing with new laws, we're dealing with new regulations, we're dealing with new guidance. All these things are happening on a daily basis. This law is developing as we speak. I don't think a day goes by where some new guidance is not distributed, whether it has to do with one of the two new laws we're going to talk about, or all the different state closure orders and how we're going to reopen things and on what phases, and how you as a business, as you as a medical practice have to satisfy your obligations to reopen and to be able to run your practice. We also have all of the old laws to deal with. Forget about the new laws. We have all the old laws, the oldies but goodies that we're all used to dealing with. The Occupational Safety and Health Act, the Fair Labor Standards Act, the Family and Medical Leave Act, all the discrimination statutes, your unemployment compensation, workers' compensation, COBRA, negligence, all of those types of claims, they haven't gone anywhere. But how they are implicated and impacted right now based upon sort of the pandemic law is something we all need to make sure we understand. Now, let's see. For some reason, I am not able to advance my slide here. Let me see if I could figure this out. I apologize.
Ooh, try that again. I might have done something. Sorry about that.
No, I'm locked up right now. I can't. It won't advance for some reason. I mean, I'll try and do it again. All right, there we go. Hopefully that'll help us out. So, what are the two new laws, right? The two new laws that most of you are familiar with: the Family First Coronavirus Response Act, the FFCRA, and the second big law is the CARES Act. Wow.
Do you want me to pull up the presentation?
You can give it a try. For some reason, it's not letting me advance the slides. I don't know why. It was working fine, but.
Alrighty, let me. Okay, sorry about that. Give us just a moment and we will share the slides from mine, which I have done this many a times for you, advanced slides for you.
Yeah, we'll be all right with that. Let me just, while we're getting to that, the Family First Coronavirus Response Act, I'm sure you're all familiar with it. You're all healthcare providers. You're all medical practices. You're all in the healthcare area. The FFCRA does not apply to you. There is an exemption to the FFCRA that excludes all healthcare providers. So basically, if an employee is employed by a doctor's office or a medical practice or a hospital or whatever it might be, you are exempt from the FFCRA. So you don't have to worry about the requirement to provide emergency sick leave or the requirement to provide emergency family and medical leave. So you don't have to worry about it. If you can go to the next slide there, Jill. And there's the exclusion there in the FFCRA. Basically, I don't think anyone on this call is going to have to deal with the FFCRA. If I'm wrong about that, somebody could send me a question and I'm happy to answer it, but I don't want to waste anyone else's time. Let's talk about the CARES Act. Go to the next slide. Well, actually, one more thing about the Family First Coronavirus Response Act. Even though you're excluded as healthcare provider employers and the act doesn't apply to you, you don't have to provide the leave, believe it or not, and I don't really understand what the point of this is, but the exemption doesn't exempt you as an employer from the posting requirement. Believe it or not, even though none of your employees are entitled to the leave provided by the act, you are still obligated to post in your workplace and provide to your employees the Department of Labor notice regarding this leave. Again, it doesn't really make a lot of sense to me, but then again, a lot of the things that our federal government doesn't make sense to me. So if we can go to the next slide. Before we get to the CARES Act, the idea of this emergency family leave, while that may not apply to you as a healthcare provider, you're still governed by the Family and Medical Leave Act, most of you, those of you that have 50 or more employees. So don't forget that that's still out there. You may not have to provide the FFCRA leave, but you still have to provide the family and medical leave to your employees if they're entitled to it. So obviously, if an employee tests positive for COVID-19 and is unable to come into work, you don't have to provide them with the FFCRA leave, but they would be entitled to family and medical leave, assuming that they've worked for you for the appropriate amount of time and that you're a large enough employer. Likewise, if somebody in their household, a spouse, a child, or a parent tests positive for COVID-19, they would be entitled to FMLA leave to take care of the person in their household who's become ill. I've had a lot of questions over the course of the last month. I know a lot of you perhaps had to stop doing business, had to furlough your employees, had to lay some employees off. Those of you that maybe only furloughed your employees, put them in an unpaid leave status, okay? You're getting to the point now where you're able to reopen and you're trying to make a decision, well, are we gonna need a full complement of people back? Or are we just gonna bring a skeleton staff back? Or are we gonna bring maybe half the people back? How are we gonna do this? And how are we gonna decide who we're going to bring back? And we start looking at the people that we have furloughed, and we notice, so that person's on FMLA leave. In addition to being furloughed, they're on FMLA leave. So there's a concern, can we ultimately terminate that person? Can we ultimately lay that person off? The answer is yes, okay? You can terminate somebody that's on FMLA leave. You can lay somebody off who's on FMLA leave. The critical issue is you just can't allow the fact that they're on FMLA leave to be a factor in your decision. So if basically you decide we're going to bring back half of our employees and we're going to do that on a seniority basis, and as it turns out, 3 or 4 people who don't make the cut on a seniority basis and are going to get laid off are also on FMLA leave, well, that's okay. There's no problem with doing that, okay? There's nothing illegal about terminating somebody or laying someone off that's on FMLA leave. The regulations of the FMLA specifically allow you to terminate somebody while on FMLA leave, as long as the fact that they're on leave isn't the reason for you terminating them. Now, the bigger FMLA issue that we're having to struggle with right now is the anxiety and the depression angle. Many of you probably have had to deal with this in the past with employees who have requested FMLA leave because perhaps they have anxiety or they have depression. That's a serious health condition under the FMLA, and they can take FMLA leave for that. They can take intermittent FMLA leave for that. So now how does that impact what's going on right now? Well, as you can imagine, you have a lot of people who are very anxious about what's going on. Many of you may have encountered this already, where you're trying to get people to come back to work and they don't want to. There may be a lot of different reasons why they may not want to come back to work, but one of the themes that we're getting is, I'm afraid to come back to work. I'm in a high risk category. I live with my elderly parents. I have very young children. I'm afraid to come back. I'm afraid I might get it and bring it home, and I'm afraid. Well, just being afraid is not an FMLA qualifying serious health condition, serious medical condition. But if somebody is diagnosed with anxiety and they share the medical diagnosis with you and you give them the FMLA paperwork and it comes back and the doctor says, yes, they have anxiety and they need to take FMLA leave for the anxiety because this whole situation has caused them a lot of anxiety, you're going to have to allow them to take the FMLA leave. There's really not a whole lot you can do about it. Where it gets really tricky is when employees want to take their FMLA leave for anxiety on an intermittent basis. What does that mean? Well, that basically means that, as you're all familiar with the way intermittent FMLA leave works, if you're expecting me to come into work tomorrow, but I wake up tomorrow and I'm particularly anxious, and I've been approved for intermittent FMLA leave for my anxiety. My doctor says it's going to be periodic, it's going to be episodic, it's going to flare up, give you some idea of how often, but it flares up tomorrow. Well, you were expecting me to come to work. Well, unfortunately for you, you're going to have to allow me to take that time off for my anxiety. And that is going to be a difficult thing that employers are going to have to deal with and struggle with as we start to get back to some semblance of normalcy, okay? And by the way, not for any other reason, just to mention this, but I completely hate the terminology everyone's using these days, the new normal. I guess I'm just an optimist, and I really hope this is the temporary normal and that we can get back to something resembling normal sometime soon. But Joe, if we can go to the next slide. The CARES Act, and we'll go advance one more. You're all familiar with the CARES Act, and I'm sure many of you have taken out these payroll protection program loans. We've gotten a tremendous amount of questions about the PPP loans. We've been approved. Now what? What happens now? Well, a couple pieces of advice to give to you. You need to keep extremely detailed and thorough records about how you spend the loan money. You should have a separate account for the loan money. You should not have taken that loan and just thrown it into your operating account and mixed it up with everything else. It's much easier to keep it in a separate account and take money out of there as you need it to pay for things that you can pay for under the CARES Act, okay? You need to keep detailed records. When it comes to forgiveness, and we'll talk about this in a slide or two, when it comes to forgiveness, which is the one thing everybody is worried about. Everyone's happy they got this money, but they all want to make sure they don't have to pay it back, right? That's the big thing. Yeah, very happy I have this loan, but I don't really want to have to pay it back, so I want to make sure I do everything that I'm supposed to do so the whole thing is forgiven. Well, remember this, the only amounts of that loan that you've taken out that will be forgiven is what you spend in the 8 weeks following the disbursement of the loan. If you haven't used the entire amount of the loan in 8 weeks, it, in our opinion, in my opinion, based on my reading of the CARES Act, you keep the rest of that money, but it basically becomes a 2-year loan at a very low interest of 1%. Okay, so, and it won't, that rest of it, obviously the rest of it won't be forgiven, whatever you've spent outside of the 8 weeks. Now, believe it or not, I've had clients come to me and tell me that their lending institutions, their banks, some banks out there are telling them that that's not the case, that whatever they don't spend in the 8-week period after disbursement, they must return. Now, I did not read that anywhere in the CARES Act. And as I said when we first started, this whole area of pandemic law is developing on a daily basis. We're constantly getting new guidance from the federal government about how this program is supposed to work. But we haven't gotten any kind of definitive guidance on that particular issue. I can only tell you that my advice is, I feel like right now, if you don't spend it, it's my understanding that it basically becomes a low interest loan that has to be paid back within 2 years, okay? Now, let's start talking about the forgivable nature of the loan. First off, you have to spend at least 75% of your loan on payroll. And we'll talk about what payroll is in a second. You cannot spend more than 25% of the loan on eligible non-payroll things. For instance, rent, utilities, mortgages that were in existence prior to February 15, 2020. If you entered into a lease in March, that will not be an eligible expense. If you refinanced a mortgage in April, that will not be an eligible expense, okay? Go to the next slide. Payroll expenses, what are they, right? 75% of how you spend this loan, at least 75% of what you spend it on is gonna have to be payroll expenses. Well, that's salaries, that's wages, that's commissions. But remember, and again, some employers have misunderstood this. If you have somebody that's making more than $100,000, their salary is more than $100,000, the entire amount of their weekly paycheck during this 8-week period is not going to be forgiven. You are only able to forgive up to whatever that paycheck would look like if they were making $100,000. Okay, so if I'm making $250,000, whatever you're paying me in that 8 weeks, only a portion of that is going to count against the loan and be considered payroll for purposes of the PPP, okay? Employee benefits are included, but only your cost. So if you pay 50% of the employee benefit premiums and the employees pay 50% of the employee benefit premiums, you can't use or try to apply 100% of the employee benefit costs towards the PPP loan. You can only apply the 50% that you actually pay, okay? State and local taxes, payroll taxes are included, okay? So you can use the PPP loan to pay for that. What is not included is any type of federal payroll taxes, federal income tax, Medicare, Social Security, Okay, you obviously are giving people their paychecks, and that's included. That's why I said it's important for you to make sure that you have your money, your PPP money, in a separate account, so that when it comes to accounting purposes, you know that it's not the entire paycheck that is attributed to the PPP money. It's only the eligible payroll expenses that are in there. And believe me, when the time comes for you to seek forgiveness, your bank is going to require you to provide detailed documentation about how every penny of that loan was spent. So you want to make sure that you have every receipt, every payroll document, every rent bill, every utility bill. And by the way, I was talking about utilities. I forgot to mention this. Utilities, for purposes of the PPP program, are not defined they're not defined narrowly like you would normally think. Well, utilities, my electric, my water, my sewer, whatever it might be. Your utilities are defined more broadly for purposes of the PPP to include things like IT costs, monthly IT expenses, cell phone expenses if the cell phone is provided for and paid for by the employer, and things of that nature. Okay, now, can you use the PPP money to give people raises at this time? Can you use the PPP money to pay out bonuses in that 8-week period that after you received the disbursement of the loan? Again, the answer is that there's no guidance on that. The federal government has provided absolutely zero guidance on whether or not that's an appropriate expenditure. My take on it is that that barring some guidance that says we can't do it, there's a raise, as long as you keep them under the $100,000, a bonus, as long as that compensation doesn't take them above an annualized amount of $100,000, it would be a qualifying payroll expense, in my opinion. If we can go to the next slide. Now, everybody wants to know about forgiveness. I'm sure most of you have probably heard this by now, so I'm not gonna beat a dead horse, but we look at the 8-week period after you get the loan. We count only the eligible expenses that are incurred and paid during that time period. Your forgiveness amount, I know you want 100%, but it will be reduced and won't be 100% if there has been a reduction in the number of full-time equivalent employees, or reduction in salary and wages for people making less than $100,000 during that time period, okay? And you basically have to establish a baseline, okay? What's the baseline for full-time equivalent employees? You have two choices. Pick the one that works best for you, okay? You have the option of February 15th, 2019 to June 30th, 2019. Obviously, if you had less employees then, that would probably be the one that you want to go with. If it's January 1st, 2020 to February 29th, 2020, if that works out better for you, then you use that. But that's the two options to establish what your baseline is, to establish how many FTEs did you have. And for purposes of the PPP, an FTE is a 30-hour-a-week person. But again, that doesn't mean you don't count somebody that was 20 hours. It doesn't mean you don't count somebody that's less than that. You aggregate all of those part-time people together and divide by 30 to get your FTE equivalent, okay? So again, if I have 20 part-time people, they're all working less than 30 hours, they don't all count the same. I add up all their hours, divide by 30, and then I come up with my standard FTE. So if we can go to the next slide there, Jill. Then we have to look at, once I establish my baseline, did I reduce employees in the relevant period? Did I reduce payroll in the relevant period? And when I talk about wages and reduce payroll, did I reduce somebody's salary? And a lot of people have had to take pay cuts during this time. But if I've reduced it by more than 25%, that is going to impact my forgiveness. Okay, it's provided that I haven't corrected it by June 30th, 2020. You can correct your reductions in force. You can correct your reduction in headcount by June 30th, 2020. okay? But again, remember, just because you correct the head count, you can't go on June 30th, 2020 and hire everybody back and say, oh, well, look here's my baseline number. I know for most of the time that I had the loan, I didn't have that many people, but now by June 30th, I do. That's great that you have them by June 30th, but that probably didn't help you in terms of spending your PPP money, because remember, you can only count the money that you spent in that 8-week time period. So it's a little convoluted, it's a little confusing, but the easiest way to understand it is you want to look at that 8 weeks after you get the loan. Use it only for the expenses that you can use it for. Ideally, you want to try to bring people back as quickly as you can during that time period so that you're able to maximize how you spend that money. If we can go to the next slide. I already talked about a lot of this. I'm going to go through this quickly. Separate your account, document all your expenses, try to get your people back to work. Now, a lot of people are coming to me with this question. We're trying to get people to come back, George, but they won't come back. We're offering people their jobs back, but they won't come back. They won't come back because they're afraid, as I mentioned earlier before, or thanks to Governor Wolf in Pennsylvania, I don't want to come back because I'm making more money collecting unemployment. Why should I come back and work for you in a medical practice where, heck, I might actually come into contact with somebody that has this? I'd rather just sit home, collect unemployment. I'm actually making more money collecting unemployment. Well, our genius governor in Pennsylvania said to employees, well, yeah, you should do that. Absolutely. Just stay home. I guess the governor of Pennsylvania isn't worried about how we're going to staff our workplace once we're actually able to start doing that. And many of you maybe are doing that right now. But what happens with respect to the forgiveness component of the PPP as it relates to the people that won't come back? Well, the good news is just 2 days ago, in some frequently asked questions released by the Small Business Administration and the Department of Treasury, they indicate that employees who refuse to return to work that have been offered their job back, as long as we offered them their job back at the same salary as it was before and the same wages and basically the same hours, if they refuse to come back to work, that will not impact negatively your forgiveness under PPP. So even though your head count may be off, it will not reduce your PPP forgiveness amount. Now, the critical thing to understand about this, you must confirm with that employee in writing that they have refused to come back to work, that you have offered them their position back at the same pay and the same hours, and that they have refused to come back to work. You need to do that in writing and hang on, make a copy of that obviously for yourself, because when the time comes for forgiveness, that's something you're going to need to provide to your bank to help you with the forgiveness element of this. We can go to the next slide. And the next one. Let's talk about unemployment compensation. A lot of changes out there in all states as it relates to unemployment compensation. Most states have eliminated the waiting week. Pennsylvania certainly has. I know, I'd say the overwhelming majority of states out there have eliminated the waiting week. Most states have eliminated the requirement to show that you're actively searching for work in order to collect unemployment. Pennsylvania has as well. The next slide. The big changes to unemployment, okay, through the CARES Act, pandemic emergency unemployment compensation. What did that do? Well, normally in every state, there's a certain amount of time, a maximum amount of time you can collect unemployment. In Pennsylvania, that's 26 weeks. Believe it or not, 26 is pretty standard in most states. Some states I've seen as high as 28 or 30. Others I've seen as low as 24 or 22, but 26 is generally standard, okay? What the pandemic emergency unemployment compensation created through the CARES Act does is it extends by 13 weeks the maximum amount of unemployment you can collect. So whatever that is in your state, add 13 weeks to it. So in Pennsylvania, we go from 26 to 39 weeks, as long as you have maximized your unemployment through the end of the year. As of right now, if you're only in week 30 as of December 31st, 2020, well then you're cut off. okay, you can collect the full 39 weeks, the extra 13 weeks, provided that you do it prior to December 31st, 2020. Then there's the federal pandemic unemployment compensation component of the CARES Act. What did that do? And this is the big one, right? This is the one that's gotten all the attention. This basically provides anybody who's collecting unemployment, who's eligible for unemployment and is collecting unemployment through their state, to receive an additional $600 a week bump from the federal government. I mean, the money basically comes from the federal government, but it ultimately gets paid out by your state. Now, this extra $600 a week runs out and expires on July 31st of 2020. And this is the component that is causing a lot of problems out there for people in terms of trying to get people to come back to work. If we can go to the next slide. Now, you've furloughed employees or laid off employees. You know, whether or not they're eligible for unemployment, that's going to depend on the specific unemployment compensation eligibility requirements that exist in all of your states, right? You obviously have to meet a certain financial eligibility. You have to be unemployed through no fault of your own. You have to be able and available for work. Okay, those are the three that are generally universal. Okay, employees whose hours have been cut. Maybe you've furloughed somebody and it's a partial furlough. So rather than working 5 days a week, they're only working 3 days a week. Well, they're probably entitled to partial unemployment for those other 2 days a week. And oh, by the way, if they're collecting partial unemployment, they can get the full $600 bump from the federal pandemic unemployment compensation. Okay. A lot of employers have asked me, how do we fill out these UC forms for employees that we've furloughed or laid off or we have to terminate because of COVID-19? Well, I think a lot of people are overthinking the question. It's very simple. You basically write down, this employee was furloughed or laid off or terminated due to lack of work related to the COVID-19 pandemic. I mean, it is literally that simple. That's what you want to put down on the form to make it very clear it is a COVID-19 related termination or layoff. And we'll get to why that's important in a second, if we can go to the next slide. The problem that a lot of you are facing, as I mentioned, I alluded to it earlier, you want your people to come back, but they'd rather collect unemployment. And I can't speak for all the other states out there, but our governor has created a problem here by encouraging that, by actively going out and telling people, yes, you should just stay home and collect unemployment. And when, by the way, when he was asked by somebody, well, how do you expect us to staff our businesses in this scenario, his flip answer was just pay people more. Pay people more. So you can chew on that for a little while. But what do you do when someone declines an offer of employment? Under Pennsylvania law and every other unemployment compensation law that I'm aware of in any other state, this employee would be ineligible for unemployment compensation benefits. If they were furloughed and they were receiving benefits, and now you say to them, your job is available and ready, I want you to come back to work, and they say, no, I don't want to come back to work, I want to stay out and collect unemployment, they should not be able to collect unemployment. They are not ready, willing, and able to work. They cannot establish the fundamental requirement for collecting unemployment compensation, and therefore they should not be eligible. Okay, you should, and then ultimately you could terminate them, and you would treat them as though they voluntarily quit. That's how you would internally treat this, as you offered them a job, they turned it down, so they quit. If we can go to the next slide. When somebody voluntarily quits, they do have the opportunity, you know, it may not be universal, I guess, that they're not going to be able to collect. But if their reason for quitting was, well, I just rather collect unemployment, well, then it will be. Okay, that's not a necessitous and compelling reason to quit. For an employee to collect unemployment after they've quit, they have to establish that they quit for a necessitous and compelling reason. Okay? Fear of COVID-19 is not a necessitous and compelling reason. That should not be a sufficient reason to quit. Now, if they have some medical condition that precludes them from coming back to work. They're in some sort of high risk category. They get advice from a doctor that they shouldn't come back. That might be a different story. Okay, but just a generalized fear of COVID-19 isn't going to do it. Okay, wanting to collect unemployment compensation benefits should not do it. Okay, if I say I have a medical reason that precludes me from coming back to work, that might do it, but think about it. I have to be ready and able to work. If I have a medical issue that precludes me from working anywhere, so I've tested positive for COVID-19 and I can't work for the next 14 days, 21 days, whatever it might be, well, I'm not really eligible for unemployment compensation at that point because I can't work. I can't work anywhere. And in order to collect unemployment, you need to be able to show that you can work. Okay, so certain medical conditions could prevent an employee from collecting benefits. If we go to the next slide. What do you do when somebody declines your job offer to come back from work because they're better off? They tell you they're better off financially collecting unemployment. You need to confirm that with them again in writing. You need to send them a letter that says, I offered you this. And this letter is going to be important not only for your PPP forgiveness, but now for unemployment purposes as well. I offered you your job back. I offered you your job back at this salary and these hours, and you refused. And this is the reason you gave me for refusing. Okay. And then what we're going to do is we're going to take that piece of paper that we're going to copy, we're going to attach it to, and in Pennsylvania, there's a special form for this, which I know Jill attached or put somewhere in this program, or it's available for you guys somewhere. I'll let her talk about that later, but we put it there so you can see what it looks like. It's called, in Pennsylvania, it's called Form UC 1921W. And the purpose of that is to inform the Department of Labor and Industry in Pennsylvania that deals with unemployment compensation that you have somebody that refused to return to work and that they should be ineligible for benefits. And hopefully that takes care of that situation. Ultimately, again, I'm giving you what my opinion is based on 25 years of handling unemployment compensation claims. I have no idea what your individual states are going to do with this. I don't even really know what Pennsylvania will do with it. They shouldn't grant benefits under these circumstances, but they might. And if they do, then you're going to be left to appeal that determination up through unemployment and ultimately into the courts if you want to get relief. We can go to the next slide. COVID-19 terminations. A lot of employers have asked me if we terminate somebody because of the pandemic, because we don't have enough work anymore, because of other reasons related to COVID-19. It's a COVID-19 related termination. Will this termination affect my unemployment compensation rate? I can tell you that just this week, Pennsylvania came out with guidance that said it will not count against you in Pennsylvania. For all of you out there in different states, you're going to have to check with whoever handles your unemployment compensation system. But I would tell you that most states are following Pennsylvania. Maybe Pennsylvania is late to the game and they're following most other states. I don't know, but most states are taking the position that employees that are laid off, employees that are terminated or furloughed because of the pandemic, because of lack of work, because the business had to shut down, those terminations will not impact your unemployment compensation rate. And again, it's critical that on the form, you make it clear the reason for their termination is this person was furloughed, this person was laid off, this person was terminated because of lack of work or because of business issues due to COVID-19. If we can go to the next slide. Some UC horror stories that I'm sure a lot of you are starting to face. Know your employers are filing for unemployment and they're not hearing anything. And everybody is calling me saying, what can you do, George? Well, I can't do anything. I don't work for unemployment, okay? There's nothing I can do and there's nothing you can do. What can we do? Nothing. There's nothing that you can do. This is an unemployment compensation problem. The system is overwhelmed right now. That's why people aren't hearing back. Quite honestly, it's Russian roulette. It's hit or miss. Some people are filing and finding out and getting benefits in a week. Other people are filing and 3 weeks go by or a month goes by and they haven't heard anything. Those people are going to get their full benefits. They're just going to have to be patient. The only thing you can encourage them to do is continue to reach out to unemployment. But I can tell you, if your state is anything like Pennsylvania, good luck trying to reach someone in person on the telephone with an unemployment compensation question. You have better luck probably, winning the lottery these days. Employers are telling me that they're returning forms to UC that are being lost, that they're subsequently getting notified by whatever state agency runs their unemployment system, saying, well, we never turned in the form. Again, that is attributable to the fact that the system is overwhelmed. Hopefully you made a copy of it, it's date stamped somehow, made a copy of the envelope that you sent, whatever it is, and you can establish when you actually sent it to them. Some of you are getting forms from unemployment with dates, deadlines to return them that have already passed. You get a relief from charges form that says it has to be filed 2 weeks ago. Again, file the form. Don't worry about it. It should all work out in the end, okay? I don't expect that you're going to have issues as far as you didn't get your forms in on time. Some of you are telling me that you have employees that are clearly ineligible for benefits and they're being given benefits. What can we do about it? Not a whole lot. I mean, you can do what you always do, which is you can appeal. You can appeal through the system and then ultimately into the courts. Everybody tells me, well, how can you be so sure, George, that this is all going to get taken care of? I can't really. I mean, I'm using the slogan trust but verify, which is trust that it will, but you're going to have to take it upon yourself to verify that it's getting fixed. You're going to have to take it upon yourself to follow up with unemployment to make sure that these things are corrected and that you're not being charged for things that you shouldn't be. If we go to the next slide. Potential discrimination claims regarding furloughs and layoffs are another big issue, something that perhaps a lot of you in the medical practice area are dealing with right now. Again, a lot of you probably, I'm sure you fall into different boats, right? Some of you never shut down at all. Some of you might have shut down and were doing only necessary type of things. All elective procedures were put aside. Some of you might have shut down completely. So you may have had to furlough people, lay people off. But now as you start to reopen, as you get the go-ahead to open up your physical office location and begin to try to get back to some sense of normalcy in your business, in your medical practice, how do we decide who we're going to bring back? The critical thing for you is to remember that these decisions are going to be scrutinized by all of your employees, particularly the employees that you don't bring back. Either you don't bring back right away or you never bring them back. I've got a lot of creative clients who think that, this is a great time, use the pandemic to sort of weed out, all the people they don't want anymore. Well, I'm not so sure that that's the greatest plan in the world from an HR perspective, from an employment law perspective. If you have an employee that was a poor performer prior to the pandemic and prior to being furloughed, and you never dealt with that issue, you never gave them any kind of written warnings or counselings, and ultimately you're going to not bring them back and terminate them because you're going to say, well, it was, performance related. Good luck with that. Okay, that's the employee that when they don't get called back, who happens to be over 40, who happens to be in another protected class, maybe disabled, or maybe in a protected race class or a protected national origin class. That's the person who's going to bring the EEOC charge against you and say, well, wait a minute, why did all these other people get brought back and I didn't? And you're going to say, well, it was performance related. And they're going to say, well, I was never warned about my performance. Show me one performance warning I ever received. Show me one performance evaluation that said I wasn't doing a good job. And then you're going to have a problem. So, you think you're getting rid of them now, only for them to resurface 6 months from now with an EEOC charge, and now you're having to deal with all the expenses that brings. So again, there are people that are going to be not brought back from furlough and terminated and laid off. You must have an objective basis for why you're doing what you're doing. I assume that you did when you initially furloughed people, unless you furloughed everybody. But if you only furloughed some people, my guess is maybe you made that determination based on seniority. Well, we furloughed the less senior people, of our nurses, of our techs, of our customer service people, of our schedulers, of our front desk people. We did it on a seniority basis, or we did it on a performance basis. You can, doing it on a performance basis is fine, as long as that's what you truly did and you have documentation to back it up. As you bring these people back now, you have to make sure you do the same thing, that you don't just, pick and choose who you're going to go, I'm going to bring this person back because I like them the best. I'm not going to bring that person back because they're a pain in my backside. They're a constant thorn in my side, and I'm probably just going to get rid of them anyway. Well, again, if they fall into a protected class, that could create a problem for you down the road. Now, it's very important that as you recall people, okay, you do so in writing, that there's some sort of communication between you and them in terms of you're calling them back and the circumstances under which you're calling them back and all these different things. Okay, so that will protect us down the road in terms of if someone else that doesn't get called back questions why, how, where, when we did this, we have the documentation to support it. Okay, if an employee refuses to come back after a recall, again, we want to make sure, again, for the third time now, and the third time is the charm. When someone tells you something 3 times, you know it's important, but you want to get that written response back to them for now 3 different reasons, right? Loan forgiveness, unemployment compensation, and now avoiding a potential discrimination claim. If we can go to the next slide. Had the first couple questions this week about discrimination issues, harassment issues regarding masks. Okay, somebody came to work with a mask created out of fabric. Well, guess what the fabric was? The Confederate flag, right? And that obviously got the ire of a bunch of other employees at this particular workplace and created a potential harassment situation. So I'm assuming that with this group I'm talking to here, you're all dealing with surgical masks and medical masks and things like that. So you probably don't have people making their own masks out of cloth and different things. But in the event that somehow that does make its way into your workplace, understand that, pictures, symbols, words, we have to be concerned about the harassment component of that as well. What if you have an employee that refuses to wear a mask claiming religious reasons or health reasons? Same type of thing. Same scenario you've got to deal with when you have somebody in the healthcare profession that says, well, I refuse to get vaccinated because of religious reasons, or I refuse to get vaccinated because of health reasons. You have to engage in the interactive process with them, determine, is there any other way around this? Is there any other reasonable accommodation we can make for them? And if so, we'll have to try and do it. My guess is now the way things are with the way masks are being viewed and that they're absolutely required for people coming back to work, I don't think there's going to be a lot in the way of leeway provided when it comes to wearing masks. I don't think there's going to be a lot of expectation for you to grant accommodations in this regard. If we can go to the next slide. Just briefly, harassment claims by employees who have tested positive. So we're starting to see employees who were out of work, and everyone knows, even though they're not supposed to know, they all can figure it out. This person hasn't been here for 21 days and it's been in the middle of this thing, and once they went out, we had to do all these different, take all these precautions and protocols and measures. Well, we all know this person had it, or on Facebook we all found out, or whatever, and now they're back, and now people are treating them differently. They're like a leper. Nobody wants to go near them because they're afraid that somehow they still have it, not realizing that we wouldn't let them back. But they somehow, oh, well, someone else in their family might have it or whatever. There's a lot of lack of knowledge out there as it relates to this, but you have to be concerned about how people are treated by their coworkers when they come back from having had this. Some employees who are flouting the mask requirements outside of work and going to rallies and posting pictures of themselves on Facebook with a whole bunch of other people, and their coworkers are seeing it, and they're angry at them. They feel now they're coming into work and they're putting them at risk, and now they're treating them poorly or harassing them in some way. Again, we have to deal with that the way you would deal with any other harassment situation, investigate it and try to address it. If we go to the next slide. OSHA, let's talk about OSHA for a second, in the sense of, OSHA hasn't gone anywhere. OSHA's still out there. You're still going to have the same responsibility to provide a safe workplace for your employees. Employees are going to make complaints, and they already are when they're called back to work. They don't want to come back to work, and so they're going to complain and notify OSHA that you're not doing what you need to do to keep them safe at work, and you're going to have to then deal with OSHA. If we can go to the next slide. I don't want you to become Magnum PI. Okay, I'm dating myself with that comment, but I don't want you to try to figure out who made the complaint. That's not going to get you anywhere. That's not going to solve anything. That's not going to move the ball forward. Deal with the OSHA investigator, deal with whatever the issue is, show them that you've done all the things you need to do, all the things that you're being recommended to do. You're following your pandemic response plan, which I'm going to talk about in a second, and therefore the OSHA investigation is going to be open and shut investigation, okay, provided that you're doing all the things that you're supposed to be doing. But let's not retaliate against any type of an employee for bringing a complaint to OSHA. That's just going to create bigger problems for you down the road as far as retaliation and things like that. Again, an employee refuses to come to work for health and safety reasons. Your job, I wouldn't just immediately terminate them. I'd make them explain to you exactly what the issue is, what the reason is. You want to try to look into it, do your best to investigate it, see if you can allay their fears by providing them with some additional information, probably from your pandemic response plan, and then, you know, go from there. At that point, if you're doing everything you can, they don't have any kind of medical documentation that would keep them out of work, ultimately that's an employee that you may have to let go and terminate, because if they won't come back to work, you got to put somebody in there that will. If we can go to the next slide. Okay, OSHA is going to continue to conduct investigations and continue to investigate complaints. They've said that. They said that what they're going to be looking for is, have you adopted a written pandemic response plan as recommended by the CDC? Do you have something in place that is going to educate your employees and communicate to your employees the steps that you're taking to protect them during these times? And if we can go to the next slide. What are the 4 critical components of a pandemic response plan? You have to summarize for your employees all the recommendations that you've been given as an employer from the CDC and from the Department of Health and everybody else in terms of what employees can do to protect themselves. That's pretty common sense stuff, but you need to do it. It needs to go in your pandemic response plan. You need to explain to them in your plan, in your written plan, what are the steps you've taken to protect them from a cleaning standpoint, a sanitation standpoint, a wipe standpoint, hand sanitizer, how often you're cleaning, the areas you're cleaning, all these types of things. Then you have to, the 3rd and the 4th requirements are the protocols. What are the protocols that you've put in place to deal with employees that you have knowledge have had close contact with someone that's infected, but the employee's not yet symptomatic? What are you doing to protect them and everybody else? What are you doing to protect them and everybody else when somebody comes to you and said they have had close contact with somebody who is infected and now they are symptomatic? What are the steps that you're taking? Those are the 4 things that must go into your pandemic response plan, and that is your get out of jail free card when it comes to OSHA complaints and investigations. Go to the next slide. The ADA. What can you do now as it relates to the ADA? The long and short of it is, it's pretty much the wild, wild west, right? Pre-pandemic, you really couldn't do anything when it comes to the ADA. You couldn't ask any questions. You couldn't take any tests. You couldn't make any kind of inquiries. At this point now, it's pretty much everything's fair game. Do you have COVID-19? Yeah, you can ask that. Have you been tested for COVID-19? Yes, you can ask that. Have you had contact with anybody? Do you live with somebody? Does anybody that you know have it? You can ask all those questions. Do you have these symptoms? You can ask those questions. Anybody you live with have these symptoms? Those questions are all fair game right now. Okay, the EEOC has said that during this time of pandemic, these restrictions by the ADA are relaxed and essentially eliminated, okay? Now, if you're gonna ask people those questions, you should generally ask everybody those questions, okay? You shouldn't just say, well, I'm only gonna ask all of our older employees. Anyone that's 65 years of age and older, those are the only people we're gonna ask those questions to on a daily basis. Those are the only people that we're gonna take their temperature on a daily basis. Okay, that's going to put you into a problem where you have a potential discrimination claim on your hands. Now, if you have an objective reason to single somebody out, so you're not asking everybody else about their symptoms, but somebody came to you and discloses that they're living with somebody who has tested positive, well then yes, you can single that person out for questioning. That's not a problem. We can go to the next slide. Just on temperature checks, you can do them. Obviously, and in healthcare establishments, you all know that. If we can go to the next slide. The critical thing is here, again, keep the records separate. Okay, the records that you're keeping of temperature checks should not be stuck in people's personnel files. They need to go in their medical records files, okay? Again, you shouldn't be picking and choosing who you're taking temperatures of. You should be doing that for everybody, okay? If you're going to do that, and most medical practices are, then you should do it for everybody. Okay, if we can go to the next slide. Potential FLSA issues. Again, you've furloughed people, and maybe you still have people out on furlough. And I actually had this issue with a hospital, fairly large hospital, that was doing this incorrectly. They had exempt employees that they furloughed. They were furloughing them one or 2 days a week. They were giving those exempt employees the option to take PTO for that 1 or 2 days a week, or take the time as unpaid. The alarm bell should be ringing right now. Ding, 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 ding. Absolutely not. You cannot allow an exempt employee to choose to not get paid their full salary on a weekly basis. The whole point of being exempt is that you're guaranteed the same salary every single week, no matter how many hours you work. Just because you are furloughing somebody and they're only working 4 days a week now instead of 5, you can't say to them, well, hey, you don't have to take your PTO. I'll just pay you 4/5 of your salary. Doesn't work that way. You have now lost their exempt status. You're treating them as a non-exempt employee. They're entitled to that money, okay? And now, because you've treated them that way, when they come back and start working a normal schedule, they'll be entitled to overtime because they're no longer exempt, because you haven't consistently treated them as exempt. Now, if you furlough them for an entire week, different story. If you furlough an exempt employee for an entire week and they do any work for you for the entire week, you don't have to pay them anything for the week, okay? But if they do 2 hours of work and they're furloughed the rest of the week, they get their full paycheck, okay? Please don't make that mistake. Forced PTO, just want to mention this for the New Jersey people out there. You cannot, if you have a 1 bucket system in New Jersey, you have 1 bucket of PTO, you can't force people to use it because of your special New Jersey ESLL, okay, that in New Jersey emergency sick leave, okay? You can't force people to take that. Therefore, if that's included in 1 bucket in New Jersey, you can't force them to use any of their PTO. That's pursuant to the most recent regulations that just came out in January of this year regarding that New Jersey ESLL. We can go to the next slide. Do you have to pay people, your non-exempt employees, as they wait in line to get their temperature checked before they come into work? Well, hopefully you're staggering their start and stop times as you are supposed to be doing, so you don't have 15 people all coming in at the same time. If you're staggering their start and stop times, my guess is it's going to take a minute or 2 at the most for people to get through a line to get their temperature checked. That would be de minimis, okay? And you would not have to pay them for their time spent waiting. If for some reason you're doing this the way our federal government probably would do it, and somehow it's taking people 15 minutes to get through a line to get their temperature checked, well then, yeah, you're gonna have to pay them for that time, okay? There's no question about it, okay? If we can go to the next slide. Well, this is the last slide, I believe. Negligence and workers' comp claims, okay? A lot of employers, including medical practices, have asked me the question, we're worried that we're going to get sued by somebody because they're going to say they got COVID-19 coming to work for us. Do we have to worry about that, George? Do we have to worry about a big negligence claim where we're going to get hit with potential punitive damages because we didn't take the right steps to protect our employees? Is that something we have to worry about? In Pennsylvania, no. In most states, no. This issue will be determined by state law. In most states, workers' compensation will be the exclusive remedy that they have. This would be considered a work injury. They got sick, they came into contact with this, they got sick at work. Their damages would be limited to collecting whatever benefits they're entitled to under workers' compensation. They cannot turn around and sue the practice, sue the hospital for negligence, that you didn't protect me, and bring some sort of major claim against you for that, okay? Your defense is going to be workers' compensation. So I think that is the last slide. We can go to the next one just to be sure, yeah. I know that we're a little bit over at this point. I apologize for that. We got off to a little bit of a late start. I'm happy to answer any questions. Obviously, if you're not interested in questions, you could drop off, but I think Jill is going to sort of take the lead on asking the questions.
Yes, thank you very much. Thank you for joining us. For those of you who want to stay on, we'll move on to some question and answers. For those of you who have to get off, there will be a recording that's posted on the PAHCOM YouTube page, hopefully tomorrow. Let me switch slides here from current slide. Here we go. Just a reminder also, besides the YouTube page, the home page has many resources. The PAHCOM member library has a whole bunch of things on COVID, so there's another resource that you can use. And yes, we are on the questions. Let me see what questions we have. We have a few of them, so let me see here. The first one was on FFCRA. Does it also exempt mental health practices and dental practices? The FFCRA.
Right. The dental practice, I'm not sure. I would say that it does. I mean, a dentist is a doctor of dentistry. So it's if you work for any doctor or medical practice. So again, there's no guidance on specifically whether it covers dentists. I would say that the mental health, again, the mental health facility, to the extent that, you know, it's considered a medical practice, and what's happening there is the provision of medical services. I would say yes, it would exclude those places. Now, again, remember, I don't know, you know, I have not researched either one of those, so I don't take that necessarily to the bank. That's my gut telling me that it would not apply to you. But if you're going to take the position that it doesn't apply to you, I think you want to be sure. So, you know, I would just have somebody actually double check that.
Okay. Another one. Have there been guidance as to whether or not employer paid disability and life insurance is a qualifying expense?
That is not covered by the guidance. The guidance talks about health benefits, you know, health insurance, dental insurance, that type of stuff. I have not seen anything on life and disability. Again, in the absence of guidance, the position I would take is that it would count. You know, to me, those are similar in nature to health benefits. Now, again, you know, if you generally pay that on a monthly basis, then I think it's going to work. If you generally pay that at the end of the year, then I'm not so sure it's going to work. You know, if you're going to try to prepay it, that may be a little bit more of a risky approach. But if it's something that, you know, just like healthcare and dental insurance, you're paying on a monthly basis, and I think you're probably okay.
Okay, thank you. Let's see, an employee became comfortable with working from home. Can they make us allow them to continue to work from home? If so, for how long? We prefer our staff in-house. This may change in that we may allow a work from home occasionally, but we never intend for this to be the permanent situation. She says she's high risk. I requested a doctor note. Currently, we have one billing person coming in per day. We would like to go to 2 people by the next level, yellow. Can I make her like the rest?
Okay, unfortunately, for some reason, Jill, in the beginning of that question, I didn't hear maybe the first, you know, 30 seconds of it. So could you just start from the beginning and then let me get the beginning of that question?
The employee became comfortable with working from home. Can they make us allow them to continue to work from home? If so, for how long?
Okay, that's good. I got it now. Yeah, this is another big problem that a lot of employers are facing. Most of us, you know, in our businesses, we never intended to have our people working from home. Yeah, I guess it was always something that existed and was a possibility, but our strong preference would be to have people work in the office where they can be held accountable, where they, you know, have supervision, and we know what's going on. Because of the pandemic, a lot of people have been allowed to work from home, and they've decided they really like it. They like getting up, you know, and working in their pajamas and working at their kitchen table or whatever it might be. At the end of the day, they have no right necessarily to stay home. Now, you're right, under the governor's, and now we're talking Pennsylvania, for those of you out there, this is sort of Pennsylvania specific. In Pennsylvania, we have a red, yellow, green system. And in the yellow system, it basically says, if you've let people work from home up to this point, you're supposed to continue to allow them to do so while you're in that yellow phase as long as possible, okay? I'm not a fan of that language, obviously. Again, you can thank Governor Wolf for that. But my feeling on it is, if you don't believe that they can do their job effectively at home, then you can require them to come back to work, okay? If you allowed them to work from home only basically as a last resort, just so that they could do something, then I think you can try to push them to come back. But as long as we have this guidance out there in Pennsylvania from the governor, and this yellow guidance is out there, that is going to be problematic for us. I've been already advising my clients to push back a little bit on that. Again, it would be a different story if the reason that she wanted to stay home, as you alluded to in your question, was that she had some doctor's note that said she should work from home, that she shouldn't come in. You know, then we're actually talking about maybe an ADA issue. Do we have to accommodate her? Would that be a reasonable accommodation to allow her to work from home? And again, generally where something maybe wouldn't have been in the past, it might be now, especially to the extent that we have allowed it. But, you know, I don't have a real definitive answer to give you, and I apologize for that. The yellow guidance is problematic for us because it clearly suggests that if we have allowed it up to this point, we should continue to allow it. I think that's very unfair for employers, because that was not the intent, I'm sure, of you allowing them to work from home at the start, but that's where you're at.
Okay, thank you. Another question: I received a PPP loan as a sole proprietor. I intend to use 100% of the funds as my payroll. Will I be eligible for forgiveness?
Well, it depends how big the loan is. I mean, if you took out a $100,000 loan, my guess is no, because if you're only paying yourself and you're only going to pay yourself for 8 weeks, there's no way you can spend $100,000 on payroll for yourself in that 8-week period. So it's really going to depend on, I don't know enough about that. I mean, if you took the loan out for the right amount, it's small enough, and it covers only your 8 weeks of pay, then yeah, you should be okay. It should be forgiven.
Okay. And they're also asking if we'll be able to provide the slides. I know the video recording will be available. Will we be able to send out a copy of these slides as well?
Sure, absolutely. We can, Jill, however I need to get that to you and you need to get it to them, yeah, we'll have slide copies available.
Okay. Can salaried employees volunteer to take unpaid PTO day?
No, I specifically said that at the very end. Maybe you asked that question before I got to it, but no, a salaried person is not permitted to volunteer to take a day as unpaid. It's just simply not allowed. The whole point of being exempt is you're guaranteed your entire salary every week, no matter how many hours a week you work. So the only option you have is to make them take PTO so that you're paying them the full amount.
Okay. Has there been any mention of extending COBRA beyond the normal 18 months due to COVID?
I saw something, oh, I'm sorry about this. There was just something just came out about COBRA, and I'm sorry, but it's not registering for me. I know that I think they extended the amount of time somebody has to elect to take to elect COBRA continuation. I'm not sure that they extended the amount of time that you can actually be on COBRA. What I remember reading was that the deadlines to elect COBRA have been extended. But as far as whether or not the standard COBRA time period that you're allowed to stay on COBRA has been extended, I don't know that.
Okay. And another one saying, just to confirm, frontline staff, if they get COVID-19, it's safe to assume it's work-related, so a workers' comp claim should be opened. Is this correct?
No. I'm saying that if that's really up to the employer, and if the employee believes they got it at work, then they're certainly free to file a workers' comp claim, and then the employer would help them do that. But again, they're a frontline worker. I'm sure they could have gotten it at work, but they also could have got it at the grocery store, or they could have got it, walking in the neighborhood with a friend or whatever. I don't think if you want to presume that, there's nothing wrong with that. I don't think you have to, but again, if it's always possible that there's some other reason that they could have contracted it. Now, if we know for a fact that one of your other employees had it, this person was in close contact with them, and then they get it, then I would say to me, that's pretty clear. But just because they're front line, I don't know that the assumption is necessarily there. Again, you can do that. I don't have any problem with you doing that, but I don't think you have to.
Okay.
It might be the safest
course. Another one
course.
is, what is the definition of employee for PPP? Is a LLC partner considered an employee?
I'm not sure that I understand the question completely. I mean, if they're an owner and they're a partner in the LLC, then yes, and they're an employee and they take a paycheck, yes, they would qualify.
Okay. And patient complains her bag was within 3 foot of a sick patient, and nursing staff did not move other patient to at least 6 feet while in the waiting area. Is there any liability?
So you're saying one patient sat right on top of another patient, and we didn't do anything to correct it? Can we potentially be liable? Is that correct?
Yes, it does say a sick patient nursing staff did not move, complains her bag was within 3 feet. So I'm going to assume, though, whether it's a person or an item, it's still within the period of time. Should we have done something about it? The way I read it as well.
Ideally, yes. I mean, right now we have to be hyper vigilant about social distancing in our waiting rooms and elsewhere throughout the workplace. And the people that have access to those waiting rooms that are looking out there, to the extent that they see that people aren't doing what they're supposed to be doing, then I would say yes, we have an obligation to fix that and correct it. Do I think that could lead to liability? I think it's unlikely unless it was extreme.
Okay, we just have a few more questions here, so I'll keep on going. Let's see, $100,000 employee that gets paid 26 times a year would need to limit to $15,384 over the 8 weeks, or to be used as PR for those employees. So it's just confirming.
I'm not sure I understand that question, so I'm not really sure how to answer it. I mean, if someone is making $100,000 a year, then their entire payroll, it's only for people that make more than 100,000 that their full payroll doesn't count towards the PPP eligible payroll costs.
Oh, she just chimed in saying, is that the limit, $15,384 that can be paid to that employee over that 8-week period? And actually, does it get flagged? I'm going to chime in with my own comment for that. A single payroll shouldn't go over a certain amount if you're a 2-week even versus the whole 8 weeks. So if you're paying weekly, there's a certain number, bi-weekly when it's annualized. Is that correct? So her question, though, is that the limit for the 8 weeks is $15,384 for that person?
I mean, unfortunately, I do not have a calculator in front of me, so I honestly don't know. I mean, if their salary is $100,000 and they're getting their normal pay in that 8-week time period, then I would assume the entire amount is forgivable and will be forgiven. I don't think you can, try to throw an extra pay period in there for them or anything like that. to play with the numbers. But, if I don't have, like I said, I'm not really sure how the math on that works. I can only tell you what the rule is. And then Jill, I didn't really follow your question.
Oh, okay, no problem, sorry. Here comes the next one. It says the part-time employee works remotely doing our scans. Since not busy hours are very low, can that person collect unemployment on his or her second part-time job? The part-time employee works remotely doing our scans. Since we're not busy, hours are very low, can that person collect unemployment on his or her second part-time job?
Again, I'm not really sure I understand the question. They're working part-time for the medical practice doing scanning. They have some other part-time job. I don't know. I mean, it would depend on what that job was, why they're out of work for that job, whether or not they've met the eligibility requirements for that job. I don't know. You know what I mean? I think we'd have to know a lot more about why they weren't working in their other job as well.
There's actually a preface to that. I'm sorry. It says, is an employee eligible for unemployment if that employee works part-time for us but has a regular full-time job? Sorry, I missed that first question. So that
I believe yes.
Okay. And can you define salary employees? Are all salaried employees exempt?
No. And that would require, probably another half an hour seminar to talk about the requirements to be exempt, but no. And that's one of the Jill's heard me say this a million times, that's one of the biggest mistakes that employers make is they assume that just because someone is salaried, that they're also exempt. In order to be exempt, the salary requirement is one requirement, but then you also have to meet all the duties requirements of a particular exemption. So briefly, the three main exemptions are the professional, the executive, and the administrative exemption. In order to be exempt under one of those exemptions, you have to be paid on a salaried basis, but you also have to meet all the duties requirements of one of those exemptions. So no, just paying someone on, if you paid your receptionist a salary, that does not make her exempt. There's no receptionist for any medical practice anywhere that's going to be exempt. So just because you pay her or him a salary doesn't make them exempt.
Okay. Looks like we might have maybe two questions left. So
okay.
The first is, if a partner gets paid a draw, not through payroll, will that be included in the PPP loan forgiveness?
If a partner gets paid
a draw, not through payroll, will that be?
So, yeah. I'm not sure. I honestly, I don't want to speculate on that. I mean, I will speculate anyway. I would assume that it would count, but whoever asked that question, I think you need to have somebody confirm that for you. I think it's too important of a question to just take my gut on it. I think it should count, but I highly recommend that you have somebody look at that for you.
All right. And this other one here says, we are psychiatric. We are figuring out our rules, but we will most likely require masks. If a patient comes in and refuses to take a mask, can we refuse to treat them and term from the practice?
I would believe so, but I mean, again, I'm not very super familiar with the rules about turning patients away and what the requirements are about that just from a medical practice standpoint. But I can tell you from the standpoint of the pandemic, and particularly in Pennsylvania, the businesses that are allowed to be open, all the essential life-sustaining businesses, you are required to require your customers, in your case patients, to satisfy these social distancing and these protection measures. So you are supposed to not allow them to come in. Now, if they have a medical reason for why they can't wear the mask, it affects their breathing. There is a sort of a catch-all exception out there, which the creative people out there are hanging their hat on, is if, well, I have a medical issue that prevents me from wearing a mask. And under the governor's guidance in Pennsylvania, you're not allowed to ask for them to back it up or support it. So the short answer is, I think you can turn them away. If I guess I would ask them why they're not putting on the mask to start. And if they say it's for a medical reason, then I don't think you can turn them away. If they say, oh, I just don't like it, or I don't believe in it, or this whole thing is a hoax, you got a lot of the conspiracy theorists out there. If that's the reason, then I would turn them away.
Okay. And we had over 100 people on the call. We still have 72. 2 new questions came in. I might as well ask them. It says, we are 100% electronic and require internet. Can I include my internet bills for the 25%?
I think you probably can. I do. But you know what? This is the thing. Again, if I were you, I would check with your bank that you took the loan out with. And make sure that they read the regs and the guidance and everything the same way we do, because you don't want to, take the money and spend it on that and then them say, oh, well, that doesn't count. So I think that it should. But the best thing with all these questions about forgiveness, ask your lender, get clarification from your lender. You don't want any misunderstandings with your lender.
Okay. And I have a follow-up clarification question here. It says, so only exempt employees are the ones who cannot be forced to take time off without pay? So only
well,
employees.
yeah, well, if you're an hourly employee and we furlough you, we're forcing you to take time off without pay. So yes, I guess if I'm understanding the question correctly, yes, the only category of employee that cannot be forced to take unpaid time is an exempt person. Because if you're exempt and you get paid, my salary is X every week, you have to pay me my full salary. Okay, now again, you can force me as an exempt employee to take a whole week off without pay. That's a different story. You can furlough me for an entire week, then you don't have to pay me. But with non-exempt employees, which is really the only other category, they can absolutely be forced to take unpaid time. You basically tell them, don't come to work. Don't come to work, don't do any work, and they don't get paid because they only get paid for the work they do.
Perfect. All right. So I do not see any new questions at the moment. Again, okay. Thank you everyone for hanging in there this whole time. We did go over, but again, it's packed with fantastic information. I could listen and to George all day and ask new questions. We will try to bring you more education. Don't forget, George does a blog. He's constantly providing information to us from all different avenues. So thank you very much, and have a great evening. And thank you, everyone.
Thank you.